Welcome to the UBC Real Estate Exam Prep Series. In this video, we dive deep into Chapter 10, the Law of Contract, with 52 practice questions designed to test your understanding and help you master key concepts. Whether you're reviewing offer and acceptance, consideration, or breach of contract, these practice questions will prepare you for the real exam. By the end of this session, you'll feel confident in applying these principles to real-life real estate scenarios. Let's get started and boost your exam readiness.
Question 1. Which of the following is not one of the three essentials for the formation of a binding contract? A. Consideration, B. Acceptance, C. Deposit, D. Offer. Correct answer, deposit. Explanation. A binding contract requires the three essentials of offer, acceptance, and consideration. A deposit is not essential for the formation of a contract, but is often used as a gesture of good faith in real estate transactions. Other options. Consideration. Something of value exchanged between the parties. Acceptance. Unconditional agreement to the terms of the offer. Offer. A proposal made by one party to another, intending to create a legal obligation if accepted. Question 2. In which of the following scenarios has the offer not been released or expired? Correct answer, D. The offeror decides to revoke their oral offer and mails a written revocation to the offeree, which the offeree has not yet received. Explanation. An offer is not considered revoked until the revocation is communicated to the offeree. Since the offeree has not yet received the mailed revocation, the offer remains valid. Other options. A. Incorrect. A reasonable time has passed, so the offer has expired. B. Incorrect. The offer is automatically terminated if the offeror dies or becomes insane before acceptance. C. Incorrect. The offer is effectively revoked when the revocation is communicated before acceptance. Question 3. Joe, a storekeeper, asked Harry, a courier, to deliver some groceries for him, which Harry did. What is the result? Correct answer. C. Harry could recover a reasonable amount from Joe for his services under the principle of quantum meruit. Explanation. Under the principle of quantum meruit, Harry is entitled to recover a reasonable amount for the services he performed at Joe's request. This principle ensures that a person who provides services is compensated fairly, even if no formal contract exists. Other options. A. Incorrect. Harry's actions are not past consideration because the services were performed at Joe's request. B. Incorrect. The Real Estate Services Act is irrelevant in this situation, as it pertains to real estate transactions. D. Incorrect. Section 54 of the Law and Equity Act deals with specific performance and related issues, not the payment of reasonable compensation for services rendered. Question 4. The essential distinction between a defect and a stigma is that. Correct answer. D. A stigma's effect on property value depends on an individual's subjective considerations, whereas a defect's impact can be objectively determined. Explanation. A stigma refers to something that affects the property's perceived value based on personal or cultural views, e.g., a murder occurring in the home. Its impact varies depending on subjective considerations. A defect, on the other hand, is a physical or structural issue, e.g., leaky roof, that can be objectively identified and measured, usually through inspection or evaluation. Other options. A. Incorrect. Stigmas typically lower perceived value, but they don't necessarily increase it. Defects generally reduce value, but this comparison oversimplifies the distinction. B. Incorrect. Not all stigmas must be disclosed. Disclosure laws vary by jurisdiction. However, defects that materially affect value or safety usually require disclosure. C. Incorrect. A stigma may not always be discovered through inspection, but this statement doesn't properly distinguish it from a defect, which also may not be visible without a deeper investigation. Question 5. Which one of the following is not a requirement to establish misrepresentation in contract law? Correct answer. D. The assertion must be in writing. Explanation. To establish misrepresentation in contract law, it is required that assertion of fact, there must be a statement of fact, not opinion. False assertion, the statement must be untrue. Materiality, the false statement must have influenced the other party's decision to enter into the contract. However, there is no requirement for the misrepresentation to be in writing. It can be oral or implied through conduct. Other options. A. Correct. An assertion of fact is essential. Correct. Misrepresentation requires the statement to be false. C. Correct. The assertion must significantly impact the decision to form the contract. Chapter 10, the law of contract. Question 6. Avoidable contract is A. One that never existed at all, even if the parties want it to exist. B. A contract that one or both of the parties can cancel. C. Unenforceable. D. The result of a void deed. Correct answer. B. A contract that one or both of the parties can cancel. Explanation. Avoidable contract is a valid contract but may be canceled or rescinded by one or both parties due to certain legal reasons, such as misrepresentation, undue influence, or a party lacking capacity at the time of formation. Other options. A. Incorrect. This describes a void contract, which is considered as never having existed. C. Incorrect. An unenforceable contract is valid but cannot be enforced due to legal technicalities. D. Incorrect. A void deed results in a void contract, not a voidable one. Question 7. On June 1st, Jem offered to buy Boo's summer cottage for $230,000, and Boo accepted. Since the cottage was on a secluded island, neither party was aware that on May 30th the cottage was struck by lightning and completely destroyed by fire. Boo has no insurance and is seeking to enforce the contract. Explanation. This situation illustrates a common mistake, where both parties are mistaken about a fundamental fact at the time of contract formation, the existence of the cottage. Since the subject matter of the contract, the cottage, was destroyed before the contract was entered into, the contract is void due to the impossibility of performance. Other options. A. Incorrect. This is not a mutual mistake, as both parties made the same incorrect assumption, not different ones. B. Incorrect. The doctrine of frustration does not apply because the event occurred before the contract was formed. Frustration applies to supervening events after the contract is made. C. Incorrect. This is not a case of non est factum or unilateral mistake. Jem understood the nature of the contract but was unaware of the destruction. Question 8. Which one of the following statements about the revocation of an offer is true? Correct answer. B. Unless consideration is paid to keep an offer open for a specific time, revocation can be made at any time prior to acceptance. Explanation. Under contract law, an offer can generally be revoked at any time before it is accepted, even if a specific expiry date is stated. The exception is when consideration, e.g., payment, is given to hold the offer open for a specific period, forming an option contract. Other options. A. An offer with a specified expiry date can be revoked unless there is an option contract in place. C. Revocation can only occur before acceptance. Once accepted, the contract is binding and cannot be revoked. D. Revocation does not need to follow the same method as the offer. It only needs to be communicated effectively to the offeree. Question 9. Which of the following is false with respect to the law of contract? Correct answer. B. The burden or liability under a contract may be assigned, provided that the requirements of the Law and Equity Act are met. Explanation. Under contract law, the burden or liability under a contract cannot be assigned. Only rights under a contract can be assigned, subject to the requirements of the Law and Equity Act. This distinguishes it from rights and benefits, which may be transferred through proper assignment. Other options. A. Correct. The doctrine of privity of contract generally limits contractual rights and obligations to the parties involved, with exceptions such as statutory provisions or contracts creating an interest in land. C. Correct. Contracts creating an interest in land are exceptions to privity, as third parties may gain enforceable rights. D. Correct. A statutory assignment must meet the specified criteria. It must be in writing, absolute and unconditional, and proper written notice must be provided. Question 10. A subject to clause in a contract of purchase and sale is correctly known as a. Correct answer. A. Condition precedent. Explanation. A condition precedent is a condition that must be fulfilled before a contract becomes binding. In real estate contracts, a subject to clause often outlines specific conditions, such as financing or inspection approval, that must be met for the contract to be completed. If these conditions are not met, the contract may not be enforceable. Other options. B. A warranty is a promise about the condition or quality of something, typically related to goods or services, and does not involve conditions that must be met for the contract to proceed. C. A condition subsequent refers to a condition that, if it occurs, can terminate an existing contract, which is not the case for a subject to clause. D. A penalty clause outlines penalties for non-performance or breach of contract, not conditions that need to be fulfilled. Question 11. If an offeror who has stated that the offer is open for 24 hours decides to terminate the offeror, correct answer, B, must communicate any revocation of the offer to the offeree. Explanation. If the offeror decides to revoke an offer before the time stated, in this case within 24 hours, they must communicate the revocation to the offeree. This ensures the offeree is aware the offer is no longer valid and avoids creating a situation where the offeree accepts the offer after it has been revoked. Other options. A. The offeror can revoke the offer at any time before acceptance, as long as they notify the offeree. C. Reasonable notice is a general principle, but the requirement in this case is to specifically communicate the revocation directly to the offeree. D. There is no requirement for 72 hours notice in this context. The revocation must simply be communicated before acceptance. Question 12. Bernadette has agreed to purchase Steve's home for $438,000. However, before the sale completes, she discovers that she has been the subject of an innocent misrepresentation that materially affects the contract. Bernadette may go to court and ask for the application of which of the following legal principles? Correct answer. C. Rescission. Explanation. Rescission is the legal remedy for a contract that has been affected by misrepresentation. It allows the affected party, Bernadette in this case, to cancel the contract and be restored to their original position. Since the misrepresentation is innocent, rescission would be the appropriate remedy to void the contract. Other options. A. Revocation refers to the withdrawal of an offer before it is accepted, not a remedy for a misrepresentation in a contract. B. Rectification involves correcting a written contract to reflect the true agreement between the parties, not applicable here as the misrepresentation is not about a written mistake. D. Rescission is the correct remedy in this situation. Question 13. A revocation of an offer is effective when? Correct answer. B. It is communicated to the offeree. Explanation. A revocation of an offer becomes effective only when it is communicated to the offeree. Merely mailing or filing a notice does not make the revocation effective. The offeree must be made aware of the revocation. Other options. A. Mailing a notice does not make the revocation effective unless the offeree actually receives it. C. A revocation does not need to be reduced to writing to be effective, though it is often done for clarity. D. Filing a notice is not the proper way to revoke an offer. Question 14. On March 7th, Alan contracts in writing to sell his home to Bob for the price of $100,000. The sale is to complete on March 31st. On March 8th, the house is destroyed. Accordingly, there has been, correct answer, B, a frustration of the contract. Explanation. The destruction of the house before the contract is completed is an example of frustration of the contract. This occurs when an unforeseen event makes it impossible to fulfill the terms of the contract, and the contract is considered void due to the frustration. Other options. A. A mutual mistake involves both parties being mistaken about a material fact at the time the contract was formed. C. A common mistake involves both parties being mistaken about a fundamental fact, but in this case, the destruction of the house is not a mutual misconception. D. Rescission refers to the cancellation of a contract, often due to misrepresentation or other issues, but frustration automatically voids the contract. Question 15. An invitation to treat is, correct answer, a request for offers. Explanation. An invitation to treat is not an offer, but rather an indication that a party is willing to receive offers. It is a request for offers, and once an offer is made, the other party can then accept, reject, or negotiate the terms. Other options. B. A legal offer is a proposal made with the intent to create a binding agreement once accepted, but an invitation to treat is not an offer. C. While an invitation to treat may involve requesting information, it is primarily about inviting offers, not gathering details. D. An invitation to treat does not create a binding contract. A binding contract is formed when an offer is accepted. Question 16. Which of the following does not relate to the topic of contract law? Correct answer. A. Depreciation. Explanation. Depreciation refers to the reduction in value of an asset over time, often used in accounting and taxation. It is not directly related to the formation or enforcement of contracts, unlike consideration, voidability, and quantum meruit. Other options. Consideration, a fundamental element of a contract, referring to something of value exchanged between parties. Voidability, a contract's ability to be voided by one or more parties due to factors like misrepresentation or duress. Quantum meruit, a principle that allows a party to recover the value of services rendered when no formal contract exists. Question 17. On May 3rd, Mary offered to buy Harvey's house, and the offer was stated to be open for acceptance until 2 p.m., May 4th. Which one of the following statements is false? Correct answer. B. Mary's offer represents an option agreement. Explanation. Mary's offer is not an option agreement. An option agreement occurs when one party pays to keep the offer open for a specified period, and the offeror cannot revoke the offer during that period. In this case, Mary's offer does not involve any payment or consideration to keep it open, so it is simply an offer that can be revoked before acceptance. Other options. A. Correct. Mary can revoke her offer before the deadline if Harvey has not accepted it yet. C. Correct. Any changes to the offer by Harvey would terminate Mary's original offer. D. Correct. A revocation by mail is effective only when the offeree, Harvey, receives the notice before accepting the offer. Question 18. Which of the following is false? Specific performances. Correct answer. A. Not granted in a contract for the sale of property if the property is unique. Explanation. Specific performance can be granted in a contract for the sale of property if the property is unique. For example, real estate is often considered unique, so a court may grant specific performance to force the seller to go through with the sale, as monetary damages would not adequately compensate the buyer. Other options. B. Correct. Specific performance is an equitable remedy and is granted at the court's discretion based on fairness. Specific performance is generally not granted if monetary damages would adequately resolve the breach. D. Correct. Specific performance requires the party in breach to perform the exact terms of the contract rather than paying damages. Question 19. Which one of the following is not a required characteristic of an offer? Answer. C. It must be made in writing in order to be enforceable against the offeror. An offer does not have to be in writing. Explanation. An offer does not need to be in writing to be enforceable. It can be made orally or implied by conduct, depending on the circumstances. What matters is that the offer is made with serious intent, in clear terms, and that both parties understand the obligations involved. Other options. A. Correct. An offer must be clear and unambiguous to avoid confusion about the terms. Correct. The offer must show that the offeror intends to be bound by it if accepted. D. Correct. The terms must be sufficiently clear so that both parties understand their rights and obligations. Question 20. In which of the following situations will a contract with an infant be enforceable against the infant? Correct answer. The contract is enforceable against the infant in all of the above situations. Explanation. A contract made with an infant, a person under the age of majority, is generally voidable, but it can become enforceable under certain conditions. If the infant affirms the contract after reaching the age of majority, performs or partly performs the contract after turning 19, or does not repudiate the contract within a year of reaching the age of majority, the contract may become enforceable. Other options. The contract is affirmed by the infant after they reach 19 years of age. Correct. An infant can affirm the contract once they reach the age of majority. The infant performs or partly performs the contract after reaching their 19th birthday. Correct. Performance of the contract after reaching the age of majority may make it enforceable. The infant does not repudiate the contract within a year after reaching their 19th birthday. Correct. If the infant does not repudiate the contract within a reasonable period, it may become enforceable. Question 21. Equitable remedies are remedies that are within the court's discretion to award. Which of the following is not an equitable remedy? Correct answer, damages. Explanation. Equitable remedies are remedies granted by the court that are based on fairness and are typically awarded when monetary damages are not an adequate remedy. These include specific performance, forcing a party to perform their obligations under the contract, and injunctions, ordering a party to do or stop doing something. Quantum meruit is also an equitable remedy, where a party is compensated for services rendered when there is no formal contract. Damages, on the other hand, are a legal remedy, not an equitable one. Damages involve monetary compensation for loss or injury suffered by the injured party. Other options: specific performance. An equitable remedy requiring the defendant to perform their part of the contract. Injunction. An equitable remedy that orders the defendant to do or stop doing a specific action. Quantum meruit. An equitable remedy awarding compensation for services when no formal agreement exists. Question 22. Duress in law can arise from. Correct answer: actual or threatened violence or imprisonment. Explanation. Duress occurs when a person is forced into a contract or action through the use of actual or threatened violence, imprisonment, or other forms of coercion. This undermines the free will of the person entering into the agreement, making it unenforceable. Other options: difficulty of performance. This alone does not constitute duress. Difficulty in performing a contract is not duress, but it may be a factor in other legal claims. Undue influence. While similar to duress, undue influence involves taking advantage of a person's position of power to manipulate them into agreeing to something. It is not the same as duress. A misrepresentation made knowingly or recklessly. This refers to fraud or misrepresentation, not duress. It involves providing false information, not coercion or threat. Question 23. Sally contracted to purchase sewing machines wholesale at $100 each, with a delivery date of November 30th. The wholesaler did not deliver the machines until December 31st. Sally had a buyer on November 30th willing to pay $250 each for the machines, but by December 31, the value had dropped to only $75 each, which is Sally's best remedy against the wholesaler? Correct answer: damages. Explanation. Sally's best remedy would be damages because the wholesaler failed to meet the delivery date, which caused her to lose out on the higher price she could have sold the sewing machines for. Damages would compensate her for the loss in value between the contract price and the market price. Other options. Quantum meruit. This remedy is used when services are provided without a formal contract or when there is no agreed-upon price. It is not applicable in this situation. Specific performance. This remedy requires the wholesaler to deliver the machines as agreed. However, specific performance is usually not granted for contracts involving goods unless the items are unique or rare. Injunction. An injunction is an order to stop someone from doing something. It would not be useful here because Sally wants compensation for a loss, not to stop the wholesaler from doing something. Question 24. If an offer is made by mail and the acceptance is mailed, when is the acceptance effective? Correct answer: when it is posted. Explanation. Under the postal rule in contract law, if an offer is made by mail, the acceptance is generally effective when it is posted, not when it is received. This rule is designed to protect the offeree from the potential delay in communication. Other options. When it is received by the offeree, this would apply in the case of direct communication or other forms of acceptance, but not under the postal rule. When it is received by the offeror, this is incorrect, as acceptance is effective once posted, not upon receipt. From the date and time of the postmark on the envelope. This is somewhat similar to the postal rule, but the key point is when the acceptance is mailed, not specifically tied to the postmark. Question 25. All other things being equal, shortening the contractual term on a constant level payment mortgage always has the effect of which of the following? Explanation. When the term of a constant level payment mortgage is shortened, the number of payments is reduced. To ensure the loan is fully paid off within the shorter time frame, the periodic payments must increase to cover the remaining principal and interest. Other options. Increasing the size of the outstanding balance payment due at the end of the term. This would apply if there were a balloon payment at the end, but shortening the term generally increases the regular payments, not a final balance. Increasing the interest rate. The interest rate is generally determined at the time the loan is made and does not automatically increase when the term is shortened. Increasing the payment frequency. The frequency of payments does not necessarily change unless explicitly stated in the loan terms. Shortening the term affects the payment amount, not the frequency. Question 26. Bernadette offers to purchase Steve's home for $438,000. However, before Steve has a chance to respond to the offer, Bernadette advises that she is withdrawing the offer. Which of the following legal terms describes what has occurred? Correct answer: revocation. Explanation: revocation occurs when the offeror withdraws their offer before the offeree has had the chance to accept it. In this case, Bernadette, the offeror, withdraws her offer to purchase Steve's home before Steve, the offeree, accepts it. Other options. Rectification. This refers to the correction of a written agreement that does not reflect the true intention of the parties. Rescission. This involves the cancellation of a contract that has already been formed, returning the parties to their original positions. None of the above. This would not be correct, as revocation is the appropriate legal term for withdrawing an offer. Question 27. Under the law of contract, which of the following is not an element of a misrepresentation by a seller that will entitle a buyer to rescind the contract of purchase and sale and claim damages? Correct answer: the statement must be one of opinion. Explanation: for a misrepresentation to entitle a buyer to rescind a contract and claim damages, the statement made by the seller must be false and material to the contract. It must be an assertion of fact, not an opinion. If the statement is merely an opinion, e.g., "this is the best house in the neighborhood," it typically will not constitute a misrepresentation. Other options. The statement must have induced the buyer to enter the contract. This is true. The misrepresentation must have influenced the buyer's decision to enter into the contract. The statement must have been one on which a reasonable person would have relied. This is also true. The statement must be such that a reasonable person would rely on it when making the decision to enter into the contract. The statement must have been made by the seller knowing it to be false or recklessly as to its truth or falsehood. This is true. A misrepresentation can be fraudulent if made knowingly or recklessly. Question 28. Where an offer has been made by post, an acceptance by post will be effective. Correct answer: the statement must be one of opinion. Explanation: for a misrepresentation to entitle a buyer to rescind a contract and claim damages, the statement made by the seller must be false and material to the contract. It must be an assertion of fact, not an opinion. If the statement is merely an opinion, e.g., "this is the best house in the neighborhood," it typically will not constitute a misrepresentation. Other options. The statement must have induced the buyer to enter the contract. This is true. The misrepresentation must have influenced the buyer's decision to enter into the contract. The statement must have been one on which a reasonable person would have relied. This is also true. The statement must be such that a reasonable person would rely on it when making the decision to enter into the contract. The statement must have been made by the seller knowing it to be false or recklessly as to its truth or falsehood. This is true. A misrepresentation can be fraudulent if made knowingly or recklessly. Question 29. Anna is interested in purchasing Elizabeth's house. In an attempt to save money, instead of hiring a licensed home inspector, Anna thoroughly inspects Elizabeth's house herself and does not find any defects or deficiencies. After the sale completes, Anna discovers a major issue with the foundation of the house that will cost $55,000 to fix. As a result, Anna sues Elizabeth for failing to disclose the issue with the foundation. Which of the following is true? Correct answer: Anna's claim against Elizabeth for failing to disclose the foundation issue will likely fail if it can be shown that any qualified home inspector would have identified the issue. Explanation: in this case, Anna conducted her own inspection and did not find any defects, and the issue with the foundation was something that a qualified home inspector would likely have identified. Since Anna did not hire a professional inspector, she may be seen as having assumed the risk of missing defects that could have been uncovered by a qualified professional. Therefore, Elizabeth may not be held liable for failing to disclose the defect. Other options. Because the deficiency in the foundation is a major issue, Elizabeth is liable to Anna, even if she did not know about the defect. This is not necessarily true. If Elizabeth did not know about the defect and had no reason to know, she may not be liable. Elizabeth would only be required to disclose this defect if Anna specifically asked about the foundation. This is not true. Sellers generally have an obligation to disclose material defects regardless of whether the buyer asks. The foundation issue is known as a property stigma. This is incorrect. A property stigma refers to a negative perception of a property due to events such as a crime or paranormal activity. A defect like a foundation issue is not considered a stigma. Question 30. John makes the following offer to Mary. I will pay you $500 to put a new rose bed in my garden. If Mary accepts, what is the result? Correct answer. An enforceable contract has been formed if an intention to create a legal relationship exists. Explanation. The offer made by John to Mary is a valid offer that can create an enforceable contract if Mary accepts it. For a contract to be formed, there must be offer, acceptance, and consideration. Here, John's promise to pay $500 in exchange for Mary putting in the rose bed is valid consideration. The intention to create a legal relationship is assumed unless stated otherwise. There is no need for the contract to be in writing for it to be enforceable in this case, as it involves a simple service exchange. Other options. There is no contract because there is no consideration. This is incorrect. Because there is consideration, the $500 for the work Mary will do. The promise to pay is past consideration, and therefore no contract exists. This is not true, as the promise is for future action, Mary's work, not for something that has already been done. There is no contract because the contract is not in writing. This is incorrect. Not all contracts need to be in writing to be enforceable, especially for simple contracts like this one. Question 31. S, a seller, offers to sell a property to A for $50,000. The offer is to remain open for acceptance until noon the next day. At 11 a.m. the next day, B offers to buy the same property for $75,000, and S accepts. At 11:30, A accepts the original offer to buy the property for $50,000. Which of the following statements is true? Correct answer. S was entitled to accept B's offer. Explanation. In this scenario, S made an offer to A that was open for acceptance until noon the next day. However, before A could accept, S received a higher offer from B at 11 a.m. and chose to accept it. Since S had the right to accept the highest offer, S was entitled to enter into a contract with B. The fact that A later accepted the original offer at 11:30 a.m. does not create a binding contract, as S had already accepted B's offer and the property was no longer available. Other options. S has entered into a contract with both A and B. This is incorrect, because once S accepted B's offer, the contract with B took precedence and A's acceptance came too late. S could have revoked the offer to A and avoided the problem. This is also incorrect because revocation would need to be communicated to A before A accepted, and S could still enter into a contract with B, as B made a higher offer. Question 32. Zelda was in a good mood one day, and she went over to her next-door neighbor Herb's house and cleaned all his gutters. When Herb returned home from work, he was thrilled by what Zelda had done, and he said, "Zelda, I am going to give you a case of wine for doing this." Weeks passed, and finally Zelda asked Herb when she could expect to receive her wine. Herb said that he had changed his mind. Zelda is now furious and wants to sue Herb in small claims court for a breach of contract. Which of the following statements is most relevant to these facts? Correct answer. Past consideration is no consideration. Explanation. In this case, Zelda cleaned Herb's gutters as a voluntary act, and Herb later promised to give her a case of wine. However, because Zelda's action of cleaning the gutters happened before Herb's promise, this is considered past consideration. In contract law, past consideration is not valid consideration for forming a binding contract. Since Zelda's actions were completed before Herb made his promise, there was no new consideration from Zelda to support the contract, making it unenforceable. Other options. An invitation to treat is distinguishable from an offer because it cannot form a binding contract if accepted. This is not relevant to the facts, as the situation involves a promise made by Herb, not an invitation to treat. A voidable contract exists until it is repudiated by the party entitled to do so. This does not apply, as there is no voidable contract here due to lack of valid consideration. Breach of a condition of a contract entitles the injured party to terminate the contract. This is irrelevant, as no valid contract was formed due to the lack of consideration. Question 33. A counteroffer has the effect in law of. Correct answer. Past consideration is no consideration. Explanation. In this case, Zelda cleaned Herb's gutters as a voluntary act, and Herb later promised to give her a case of wine. However, because Zelda's action of cleaning the gutters happened before Herb's promise, this is considered past consideration. In contract law, past consideration is not valid consideration for forming a binding contract. Since Zelda's actions were completed before Hiro made his promise, there was no new consideration from Zelda to support the contract, making it unenforceable. Other options. An invitation to treat is distinguishable from an offer because it cannot form a binding contract, if accepted. This is not relevant to the facts, as the situation involves a promise made by Herb, not an invitation to treat. A voidable contract exists until it is repudiated by the party entitled to do so. This does not apply, as there is no voidable contract here due to lack of valid consideration. Breach of a condition of a contract entitles the injured party to terminate the contract. This is irrelevant, as no valid contract was formed due to the lack of consideration. Question 34. Scott, the fee simple owner of Blackacre, registers an easement over a neighboring property, Whiteacre. Sven, the fee simple owner of Whiteacre, subsequently sells Whiteacre to Alice. Which of the following statements is true? Correct answer. Because privity of contract does not apply to contracts creating an interest in land, Scott may enforce the easement against Alice. Explanation. An easement is an interest in land that runs with the land, meaning it binds successors in title if properly registered. Since privity of contract does not apply to interests in land, and assuming the easement was registered on title, it is enforceable against Alice, the new owner of Whiteacre. Other options. Because the easement was agreed to between Scott and Sven only, Scott cannot enforce it against Alice. This is incorrect because the easement as an interest in land is enforceable against future owners if properly registered. Because interests in land run with the owner, the easement was extinguished as soon as Sven sold Whiteacre. This misstates the law. Easements are attached to the land, not the owner. Scott may only enforce the easement against Alice if it is a statutory right-of-way. While statutory rights-of-way are enforceable without privity, this rule applies to all easements that are properly created and registered. Question 35. When a contract is executed under seal, the seal, correct answer, stands in the place of consideration. Explanation. A contract executed under seal does not require consideration to be binding. The seal signifies the solemnity and enforceability of the promise, effectively substituting the need for consideration in common law. Other options. Constitutes a written acceptance. This is incorrect. A seal does not represent acceptance. It signifies formalization of the contract. Takes the place of the signature of the offeror and offeree. This is incorrect. A seal does not replace the need for signatures. It serves as additional formal proof of intent. Represents intention. While a seal may imply intent, its primary legal function is to substitute for consideration, not to merely represent intention. Question 36. Garfield, a licensee, was representing a seller, Madison, in the sale of his house to Tyler. After the sale completed, Tyler discovered that the main and lower floors of the house sloped. Garfield, Madison, and Tyler had not noticed this before, although the defect was discoverable using ordinary diligence. Based on the above, which of the following statements is true? Correct answer. Neither Garfield nor Madison are liable to Tyler for failing to bring the defect to Tyler's attention. Explanation. The sloping floor is considered a patent defect, a visible defect discoverable by a buyer through ordinary diligence or inspection. Sellers and their agents are not legally obligated to disclose patent defects, as it is the buyer's responsibility to inspect the property thoroughly. Other options. Garfield had a duty to inspect the premises for soundness and structural defects before advertising it for sale. This is incorrect. Licensees are not required to inspect for structural defects. Their duty is to disclose known material latent defects, not patent defects. The sloping floor is a patent defect that should have been brought to Tyler's attention. This is incorrect because patent defects do not need to be disclosed by the seller or agent. Question 37. As a general principle, which one of the following is the proper method of communicating acceptance of an offer? Correct answer: in the same form as the offer. Explanation. As a general principle, acceptance must be communicated in a manner consistent with the terms or form of the offer. If the offer specifies a particular method of communication, the acceptance must follow that method. If no method is specified, acceptance may be communicated in a reasonable manner, often matching the form of the offer. Other options. In writing, while written acceptance is common, it is not always required unless specified by the offer. By registered mail. This method might be acceptable in certain cases but is not a general rule unless stated in the offer. By telephone. This can be appropriate for verbal offers but is not universally required or applicable in all cases. Question 38. Bob and Margaret execute a contract under seal. Which of the following is true? Correct answer. Because of the seal, there is no need for consideration. Explanation. In contract law, a seal signifies a formal and deliberate commitment to the contract, and traditionally it eliminates the need for consideration. This means that the promise or obligation in a contract under seal is enforceable even if no exchange of value, consideration, occurs between the parties. Other options. Because of the seal, there is no need for written acceptance. Incorrect. The seal does not eliminate the need for acceptance to be communicated according to the terms of the offer. Because of the seal, neither party needs to sign the contract. Incorrect. A signature is generally required to show agreement even in contracts under seal. Because of the seal, they do not need the intention to contract. Incorrect. Intention to create legal relations is always required for a binding contract regardless of the seal. Question 39. Latent defects are defects that are unknown to the buyer and that are correct. Answer. Not discoverable upon a reasonable inspection of the property. Explanation. Latent defects are hidden issues in a property that cannot be identified through a reasonable inspection. Examples include structural problems concealed behind walls or issues with underground systems. These defects are typically unknown to the buyer and seller at the time of the transaction. Other options. Immediately visible to the eye of the average person. Incorrect. This describes patent defects, which are obvious upon inspection. Required to be disclosed by the buyer to the seller. Incorrect. The seller or their representative has the responsibility to disclose known latent defects. The responsibility of the licensee to discover. Incorrect. A licensee is not expected to uncover latent defects that cannot be identified through reasonable diligence. Question 40. Where no time period is stipulated in an offer, the offer, correct answer, will lapse after a reasonable time. Explanation. If an offer does not specify a time for acceptance, it remains open only for a reasonable time, depending on the circumstances, including the nature of the transaction and the method of communication used. Other options will lapse in 24 hours' time. Incorrect. There is no fixed rule that an offer lapses in 24 hours unless explicitly stated. Will lapse in 2 hours' time. Incorrect. The time period depends on the context of the offer, not a fixed short interval like 2 hours. Will not lapse, but rather it must be revoked by the offerer. Incorrect. Offers naturally expire after a reasonable time even without revocation. Question 41. On March 7th, Alan contracts in writing to sell his home to Bob for the price of $100,000. The sale is to complete on March 31st. Unknown to either Bob or Alan, the house was destroyed on March 6th. Accordingly, there has been, correct answer, a common mistake. Explanation. A common mistake occurs when both parties to a contract are mistaken about a fundamental fact that existed at the time the contract was made. In this case, both Alan and Bob were unaware that the house had been destroyed prior to the formation of the contract, making the agreement impossible to perform as intended. Other options. Mutual mistake. Incorrect. A mutual mistake arises when each party misunderstands the other's intentions or terms of the agreement, which is not the case here. Frustration of the contract. Incorrect. Frustration applies when unforeseen events occur after the contract is formed, making performance impossible. Here, the event occurred before the contract. Anticipatory breach. Incorrect. This refers to one party indicating they will not fulfill their obligations under the contract before the performance is due, which is not applicable here. Question 42. Frank sends a letter to Joe saying, "I will sell you 200 dozen widgets for $1,200. Before Joe receives the letter, he sends an email to Frank offering to buy 200 dozen widgets for $1,200. Given this information, which of the following statements is true? Correct answer. There has not been a valid offer and acceptance, and therefore a contract has not been formed. Explanation. For a contract to be formed, there must be a valid offer and acceptance. In this scenario, 1. Frank's letter constitutes an offer to sell 200 dozen widgets for $1,200. 2. Joe's email, though identical in terms, is an offer from Joe, not an acceptance of Frank's offer, because Joe had not yet received Frank's letter. Since both parties made offers without one party accepting the other's offer, there is no valid offer and acceptance, and therefore no contract has been formed. Why not the other options? Option 1, binding contract. Incorrect. A binding contract requires an offer and an acceptance. Here, both parties made separate offers without knowledge of the other, so no acceptance occurred. Option 2, requirement of writing. Incorrect. While Section 59 of the Law and Equity Act requires certain contracts, e.g., for the sale of goods, to be in writing to be enforceable, this situation does not reach that stage because no contract was formed due to the lack of offer and acceptance. Option 4, both 2 and 3. Incorrect. While it's true that no contract has been formed, option 3, the issue of writing under Section 59 does not apply here because there was no agreement in the first place. Question 43. Which of the following will not serve to discharge a contract? The correct answer is a patent defect. A patent defect is one that is visible or apparent and can be discovered through a reasonable inspection. It does not discharge a contract. On the other hand, the other options agreement between the parties, frustration, and performance of mutual obligations can all serve to discharge a contract under certain conditions. Other options. Agreement between the parties can discharge a contract through mutual consent, rescission, or modification. Frustration discharges the contract when an unforeseen event makes performance impossible. Performance of mutual obligations discharges the contract when both parties fulfill their obligations. Patent defect does not automatically discharge the contract. It may be grounds for a remedy, but not discharge. Question 44. On May 3rd, Mary offered to buy Harvey's house. The offer was stated to be open for acceptance by mail or telephone until 2 p.m. on May 4th. Which one of the following statements is true? Correct answer, C. If Harvey makes any substantial changes to Mary's offer prior to accepting it, Mary's original offer is terminated. In contract law, when an offeree, Harvey, makes a substantial change to the offeror's original offer, it is considered a counteroffer, not an acceptance. A counteroffer terminates the original offer. This means that Mary's original offer is no longer valid once Harvey proposes significant changes. The contract cannot be formed unless Mary agrees to the counteroffer, thus making a new offer that would be accepted or rejected by Harvey. Explanation. A. Incorrect. If Harvey mails his acceptance, it is effective when sent, not when received. Incorrect. Mary can revoke her offer any time before acceptance. C. Correct. A substantial change makes it a counteroffer, terminating the original offer. D. Incorrect. A question about intentions doesn't terminate the offer unless it alters its terms. Question 45. Which of the following will not result in the release or expiry of an offer? The correct answer is A. The illiteracy of the offeree. The illiteracy of the offeree does not affect the validity of an offer. An offer remains open unless explicitly revoked or terminated under other circumstances, such as the expiry of a time limit, a counteroffer, or communication of revocation. Therefore, illiteracy does not invalidate an offer as long as the offeree can otherwise understand the terms. Explanation. A. The illiteracy of the offeree does not invalidate or release an offer. An offer is still valid even if the offeree is illiterate, as long as the offeree is able to understand the terms, via assistance, for example. B. The expiry of a specified time limit in the offer prior to acceptance. This results in the offer expiring when the specified time limit is reached. C. A counteroffer by the offeree. A A counteroffer terminates the original offer. D. Revocation of the offer communicated to the offeree by the offerer. Revocation is valid when communicated to the offeree before acceptance. Question 46. On January 1st, Abdul placed an advertisement on CQXR radio station offering squash lessons for $30 per hour. Lois heard the ad and phoned Abdul on January 3rd and said, "I want to take squash lessons, but I'm a student. Do you give a lower rate to students?" Abdul said that he only had one rate of $30 per hour. Lois said she would phone back. On January 5th, Lois phoned Abdul and said she accepted Abdul's offer. Which of the following statements concerning Abdul and Lois is true? Correct answer, C. Lois's January 3rd call was a request for information, and Abdul's response on January 3rd was an offer. Explanation. A. This is incorrect because an advertisement is typically not an offer but an invitation to treat. Abdul's ad was an indication that he was open to offers, not an offer itself. B. This is incorrect because Lois did not make a counteroffer on January 3. Instead, she asked for more information about student discounts, which is a request for clarification. C. Correct. Lois's January 3rd call was a request for information regarding student discounts. Abdul's response, stating he had a fixed rate of $30, was a clear offer to Lois, establishing the terms of the agreement. D. Incorrect. Lois did not make a counteroffer on January 3. She was simply asking a question. A counteroffer would involve a change in the terms of the offer, which did not happen here. Question 47. A owes B $1,000. B assigns the debt to C. For this to be a statutory assignment, 3 requirements are necessary. Which one of the following is not one of them? The correct answer is, the notification from A to B must be in writing. Explanation. For a statutory assignment of a debt, the requirements are as follows. A. The assignment from B to C must be for the entire amount. This is a valid requirement. A statutory assignment requires the full debt to be assigned, not a partial amount. B. The assignment from B to C must be in writing. This is true. A statutory assignment must be in writing to be enforceable. C. The notification from C to A must be in writing. This is also true. To complete a statutory assignment, C must notify A in writing that they are now the party to whom the debt is owed. D. The notification from A to B must be in writing. This is not a necessary requirement. A's notification to B is not part of the statutory assignment process. The key notification is from C to A, thus D is the correct answer, as it is not a requirement for a statutory assignment. Question 48. Which of the following statements concerning a corporation's capacity to contract is true? Correct answer. C. Any person may ascertain the legal capacity of a corporation to contract by reviewing its incorporation documents maintained at its official records office. This is true. The legal capacity of a corporation is generally outlined in its incorporation documents, which can be accessed by the public at the official records office. These documents specify the purposes for which the corporation was formed and its powers, including the capacity to contract. Explanation. A. Under the Business Corporations Act, a contract entered into by a company before that company exists cannot be ratified after the company is formed. This is incorrect. Under the Business Corporations Act and similar legislation in some jurisdictions, contracts made by individuals on behalf of a company before it is incorporated may be ratified once the company is formed, provided the corporation adopts the contract after its incorporation. B. There can never be a limitation on the legal capacity of a corporation to enter a contract because a corporation can contract just as an individual person can. This is incorrect. While a corporation has the legal capacity to contract, there are limitations based on its articles of incorporation or corporate bylaws. These limitations may restrict certain types of contracts. Question 49. The courts will never allow the remedy of specific performance where, correct answer, C. Damages are considered to be an adequate remedy. The courts will generally not grant specific performance if monetary damages would be an adequate remedy for the plaintiff. If a breach of contract can be adequately compensated with a financial award, specific performance is typically not ordered. Specific performance is an equitable remedy and is only available when damages are deemed insufficient to remedy the harm. Thus, the correct answer is C, because specific performance is generally denied when the plaintiff can be adequately compensated with damages. Explanation. A. The plaintiff is a limited company. This is incorrect. The status of the plaintiff, whether a limited company or an individual, does not automatically prevent the remedy of specific performance. Specific performance may be granted to companies just as it can be granted to individuals, depending on the circumstances of the case. B. The defendant is without means. This is incorrect. The inability of the defendant to pay does not necessarily preclude a court from granting specific performance. Courts can still order specific performance if the other conditions are met, though enforcement may be difficult if the defendant has no means. D. The contract has already been partially performed. This is incorrect. The fact that a contract has been partially performed does not preclude the granting of specific performance. In many cases, courts will still grant specific performance even if partial performance has occurred, if the other conditions for specific performance are met. Question 50. Charlotte offered to sell her property to Dennis for $180,000 by email. Dennis emailed, "Send lowest cash price, will give $165,000 cash." Charlotte replied, "Cannot reduce price." Dennis then accepted the original offer, but Charlotte refused to sell, claiming that there was no contract. Which of the following statements is true? Correct answer. A. There is no contract because Charlotte's reply was not a renewal of her original offer. Explanation. There is no contract because Charlotte's reply was not a renewal of her original offer. This is correct. Charlotte's reply, "cannot reduce price," was a refusal of Dennis's counteroffer and did not reinstate the original offer. By rejecting the counteroffer, the original offer was terminated, and there was no contract formed when Dennis later attempted to accept the original price. A contract would require clear acceptance of the offer, and here Charlotte's refusal meant no agreement was reached. Thus, the correct answer is A, because Charlotte's reply effectively terminated the original offer and no contract was formed. Other options. B. Charlotte's reply to Dennis's first wire was, in effect, a counteroffer on the same terms as her original offer. This is incorrect. Charlotte's reply, "cannot reduce price," was not a counteroffer, but a rejection of Dennis's counteroffer. A counteroffer is typically a new offer with modified terms, and Charlotte did not make a new offer, but instead refused Dennis's attempt to negotiate a lower price. C. Charlotte may successfully claim that her initial price of $180,000 was an invitation to treat, and therefore she was entitled to refuse Dennis's offer to pay that amount. This is incorrect. An invitation to treat is not an offer, but an indication that the seller is willing to negotiate terms. However, in this case, Charlotte made a clear offer to sell her property for $180,000, which was not an invitation to treat. Once Dennis made a counteroffer, Charlotte had the opportunity to accept or reject it, but her reply was a rejection, not a continuation of negotiations. Question 51. Which of the following is not an example of a breach of contract? Correct answer. A. Don contracted with Tony to buy his car. The night before Don was supposed to pay the price and take the car, the vehicle was struck by lightning in Tony's driveway and destroyed. This is not a breach of contract because it falls under the doctrine of frustration. Frustration occurs when an unforeseen event, like the car being struck by lightning, makes the performance of the contract impossible. In this case, Tony is not in breach since the destruction of the car was beyond their control, and the contract can be discharged due to frustration. Thus, A is the correct answer because the situation described is a case of frustration, not breach of contract. Explanation. B. This is an example of a breach of contract. Quinn's action of telling Babs he would not be renting the motorhome is a direct refusal to perform the terms of the agreement. C. This is a breach of contract because Fred sold the hockey cards to Andrew after agreeing to sell them to Jordan. Selling the cards to someone else constitutes a failure to perform under the contract with Jordan. D. This is a breach of contract. Adrian's failure to appear on the agreed date, September 1, to paint Woody's house constitutes a refusal to perform the contract, even though he didn't respond to Woody's attempts to contact him. Question 52. The court will not normally grant the remedy of specific performance where? Correct answer, C. Damages are considered to be an adequate remedy. Explanation. The court will not grant specific performance, an order requiring the defendant to fulfill their contractual obligation, in situations where damages, monetary compensation, are considered to be an adequate remedy for the injured party. Specific performance is typically reserved for cases where the subject matter of the contract is unique, e.g., land or rare items, and damages would not adequately compensate the plaintiff. Therefore, C is correct because specific performance is usually denied when a monetary award can adequately compensate the injured party. Other options: A. The fact that the plaintiff is a limited company does not generally bar the court from granting specific performance. B. The defendant being without means does not automatically prevent specific performance, though it might affect the feasibility of enforcing such an order. D. The fact that the contract has been partially performed does not necessarily prevent specific performance as long as the terms of the contract remain enforceable.